Hey, Stargazers, if you have ever lost a federal deal and thought, should we protest this? You already know how tough of a question that is. Most GovCon leaders, we treat bid protests as a last-ditch legal move. But what if we've been thinking about this all wrong? David Timm lives this every day. David Timm is a partner at Burr Forman, chair of the bid protest committee for the Federal Bar Association Government Contracts section, and he litigates protests and claims before the Government Accountability Office, the U.S. Court of Federal Claims, and the U.S. Court of Appeals for the Federal Circuit. In this episode, David walks us through how to think about a bid protest. This is all about understanding when and how to protest a decision. Is it an operating risk, or is it the right thing to do? Learn how David Timm thinks about bid protests and what they mean for us in GovCon. All right, here's the episode. Hey, David, thank you so much for being on the Stargazy Brief. It's wonderful to have you on.
Delighted to be here.
Yeah, for those of you who don't know, David knows just about everything there is to know about claims when it comes to bids in U.S. federal contracting. When I talk with companies, a lot of them say that they think their protests are starting way after they lose. But in your experience, what are the earliest signs? Like, is it during capture? Is it Q&A, amendment season?
Yeah. Well, so to start off with, there are two types of protests, two basic types of protest. And one is like a challenge to the terms of the solicitation itself. And so that's called a pre-bid protest. And that one tends to have a higher success rate because generally you want to engage with the government through the RFI and the Q&A process. But let's say that you get a bid or an RFP and you're reviewing it and you're considering bidding on it and you see something that doesn't make sense to you. It can often have a much higher ROI to clarify that question that you have with the government before you end up bidding. And then, there's a couple doctrines depending on whether you go to the Court of Federal Claims or to the Government Accountability Office that prohibit you from protesting the terms of the solicitation after you've bid and the project has been awarded. So you need to do that beforehand on the front end. And like I said, those tend to be more successful. And the simple answer is because nobody has won yet. And so there's no intervener, there's no awardee who has vested interests in making sure that they protect the award that they received. On a post-award protest, the issues range pretty substantially. But generally, the GAO's annual report tends to tell us that some sort of inaccurate technical evaluation is the main reason that protests arise. Understanding exactly what you're proposing and how they match up with what the government is asking for, whether it be past performance or the price that you're proposing or the way that you're saying you're going to accomplish the work, making sure that that is extremely clear in your proposal so there's no room for ambiguity or misinterpretation when the government is doing their evaluation. That can help prevent protests on the front end.
Let's say that I'm a growth leader and I'm deciding whether I want to protest a bid or not, or if it's a claims problem. How can, like a non-lawyer, let's say I'm not a lawyer because I'm not, but how can I understand the difference between challenging an award or seeking money or time after like a performance starts, and then also recognizing there's no recovery path, like there's no point in even trying. How do I figure out my options? Or do I have to talk to a lawyer? What does that look like?
I don't think you have to talk to a lawyer, although I'm biased and I think that it's good to have like a 10 or a 20-minute conversation with someone after you lose an award and just say, hey, I don't know what I don't know. Is there something here? Or is this just going to be an effort in throwing good money after bad, which we don't want to do? I would say that in 8 or 9 times out of 10, when someone calls me and they're upset and they say, we're thinking of protesting this, I take a look and we generally tell them to save their money for the next proposal. And that's because that the types of errors that would result in a good result, which is typically either a recompetition or actually receiving the award of the contract, the paths to get there tend to be pretty narrow because of the way that the law is designed. And a lot of times when people call, and I don't blame them for this, they really wanted to win the award and they thought that their proposal was very good and they thought their price was very competitive, and they have a lot of ego wrapped up and a lot of vested interest wrapped up in winning. And I think that can have an emotional valence that comes over the decision-making process. And so it's good to have somebody who has a little bit more objectivity to take a look. So that's what I think about protests. Now, if you are trying to make some sort of claim for money after the performance of a contract, usually you want to figure out whether you're going to have entitlement very early on. And that's probably during performance of the contract. If there's some sort of delay, right? Or if the government is telling you to do work that is like out of the scope of your contract, then you need to figure that out quickly and reserve your rights. Otherwise, if you wait too long, you may have forfeited the ability to make that claim on the back end. I would say that comparing protests and monetary claims, the monetary claims tend to be a little bit clearer. Right? The company knows whether they're making money or not.
Yeah.
In accordance with the way that they propose the work and the way that they think the contract is going to go. And so disputes arise all the time during the actual performance. And sometimes you want to keep the client happy, and that makes total sense. So you need to pick your battles and you need to figure out, is this going to be a really big deal that's going to impact our profitability, or are we going to make any money at all? Or are we going to lose money on the contract? And that's when you need to start seriously asking yourself, have we made the proper reservation of rights? And that at that point, it might make sense if you've got that inkling in the back of your mind to call somebody, not necessarily me, but somebody that you've got a relationship with that can help you figure those things out.
Yeah. So let's say I just lost, and I think I should have won. I think I should talk to somebody. I think we do need to protest the bid. What should I be doing in that first 72 hours, other than crying to sleep? Like what should I be doing?
Well, it's a stressful thing to have to consider litigation. And I think just as a preliminary matter, people tend to be very nervous about protesting because they're worried about it sabotaging their future efforts with the client, with the government
Yeah.
agency. And so I do want to say that's a real concern. And I think in some situations, especially if it is just an ego-driven protest that's going to delay the project, a lot of times in post-award scenarios, the government has to stop everything they're doing. The awardee can't move forward with the project until the dispute is resolved. And so it can cause a lot of hurt feelings, particularly if the government knows and you know that there isn't much to the protest in terms of substance or merit. But I think generally speaking, like the government is big and agencies are big. And so you need to know your customer. I think that's the first thing. You need to know, are you working with that particular team, with that particular office, where the contracting officer is going to be the same for the next 10 projects that you bid? Or is this something that we went after and we weren't planning on working with this particular part of the agency again, and so hurt feelings wouldn't be as big of a deal to our future efforts with them. Now, I think that it's also important to remember that there are many contracting officers, even within a specific agency. They turn over all the time. And on top of all that, if you had a legitimate point to make, the government is generally going to respect that you have a legitimate point. Don't forget that the contracting officers and the government want to get things right. And so a lot of times when you bring a bid protest, you say, hey, we think there was something wrong with the process. And the government says, yeah, I think you're right. And then they redo it. And you don't even have to litigate it beyond filing the initial protest. But going back to your question about what should you do in the first 72 hours, I think this starts with a good internal process for debriefings. So if you've lost the award, you think you should have gotten it, depending on whether you're doing business with Department of Defense, you can get an enhanced debriefing. DoD offers enhanced debriefings, which tend to be much better than what is required by the federal acquisition regulations for other protests or other agency awards. But each agency, each contracting officer has a different approach in how they communicate with the unfortunate bidders who weren't selected. And so I think that's the first place to start. You need to see, what can we do better and what information can we get about why we lost in the first place. After that, it's really important to be mindful of the timelines. If you're going to the Government Accountability Office or the agency itself in an agency protest, the timelines are extremely strict, and they tend to be, 10 days within the time that you knew or should have known, or within 5 days of a debriefing. And so that turnaround can be very difficult sometimes if you don't have your ducks in a row. And I think that involves knowing or having an idea from the debriefing whether there is a there to protest.
Hey, I'm interrupting you because I wanted to remind you that Stargazy is more than just a fun podcast and a fun community where proposal people can go and talk to each other about what's working and what's not working. It's also a place where you can talk to proposal tech leaders and find the right proposal tech for you. And if you are in the midst of looking for a new proposal software, that is where you can go. You can shortlist them, read a little bit more about them on Stargazy so you don't get any sales from proposal tech salespeople. But just as fun as you can go directly to the community and ask people if they've used that proposal tech, what they think, if they like it, don't like it, what they love about it, what they don't love about it, so that we can help each other out, make sure that we're using the right technology for our use case and that we are making smart buying decisions going forward. All right, back to the episode. How can I know there's something real there for me to protest? Are there top reasons where people should be protesting? Like if I'm sitting back and I have a process I want to create of saying this is when I protest and this is when I don't, what tends to be some of those red flags I can look at to say we should be protesting? This isn't just hurt feelings or ego.
Yeah, I think it's probably worth spending some time and talking with an attorney about your business so that they understand what problems typically arise or could arise when you're in a situation where you may or may not win an award and might have to protest. Depending on what sort of work you do, uh, or what sort of contract you're after, the types of protests can vary pretty significantly. Earlier, I mentioned that an improper evaluation of technical tends to be one of the main reasons that protests are sustained. But there's other protests that are easier to resolve, and a lot of those tend to deal with whether you satisfied the basic terms of the RFP or the RFQ. So let's say that it required that you have past performance of X, Y, or Z, and you thought that you provided that proper past performance, but they eliminated you or you didn't make it into the competitive range. Those discussions tend to be pretty factual. They don't tend to have to fall into that vague discretionary place where we see a lot of protests die. When the Government Accountability Office or the Court of Federal Claims is reviewing protests, they tend to afford a lot of discretion to the agency about decisions related to their contract. After all, they're the person who is going to be the owner and be the beneficial recipient of the work that you're going to be doing. And they're the experts on what they're trying to achieve. So GAO and the Court of Federal Claims don't tend to substitute their own judgment for the judgment of the agency. So you want to get out of that sort of gray area. If another competitor gets in or is awarded the contract and it's clear that they were not eligible for some reason that because you know your competitors pretty well, let's say it's a set aside contract for small business and you know that your competitor is not a small business, or this might be a little bit more subtle, the competitor is using a large subcontractor to do too much of the work that violates the limitations on subcontracting, or it's a violation of the ostensible subcontractor rule. The fact that you know already in advance your competitors pretty well and who they might be working with could be a big advantage in figuring out whether it might make sense to protest.
Has anything changed lately, especially the past year or two, of what tends to win or lose in these claims?
Yes, that is a great question. So GAO recently, last year, in the middle of the year, issued a report and they said that they were clarifying their pleading standard. Actually, before I get into this, I want to back up and talk about the three places that you can protest very quickly. And I like to think about it in terms of the major leagues, the minor leagues, and and T-ball. Okay. So at the top, the place that you're going to get the best review, it's the major leagues, it's the Court of Federal Claims. They're going to be much less deferential to the agency in the decisions that the agency makes compared to GAO or the agency. The minor leagues are going to be GAO. It's a good place to go if you think you can get quick resolution of the protest because it tends to be cheaper. The pleading requirements The filings that you have to do are much less formal at GAO. On the downside, the timeline for filing is very strict compared to the Court of Federal Claims, which has a more loose standard for timeliness. I think that, that difference in the scrutiny that GAO and the Court of Federal Claims put on the decisions the agency has made is often the difference between winning or losing a protest. And that's illustrated nowhere more clearly than a protester first goes to the Government Accountability Office and loses, and then takes a second bite at the apple and goes to the Court of Federal Claims and wins. And I've been in this situation where the GAO doesn't give you the full administrative record, or they redact too much of the administrative record. So salient facts that you need to make your argument compelling to GAO are not available to you there. But then when you go to the Court of Federal Claims, because the record tends to be much more expansive and Court of Federal Claims generally wants to see everything, whereas GAO has, a 100-day resolution time period that they're, trying to work within. A lot of times you can discover things that at Court of Federal Claims you would never have gotten, and it'll result in a protest win. Agency is like T-ball, and it's very easy for people to understand this intuitively. The agency, it's supposed to be a review at a level above the contracting officer, so it's supposed to be somewhat objective. But at the end of the day, the agency, maybe they'll do the right thing. But if they disagree with you at all, I think that it's very likely that you're going to lose that protest. Is that helpful for explaining the three different places you can go?
To me, that's really helpful. But would I always start out at GAO and then kind of move up or do I have to start out at the agency level and move up, or are there reasons for me to go straight to the top?
Yeah, I think that, no. So you can go to any one of the three. You don't have to start off, in the T-ball scenario and then go to the minor leagues, then the major leagues. The
Gotcha.
reason that I mentioned people go from GAO to the Court of Federal Claims is because of that timeline, the difference in the timeline between GAO and the Court of Federal Claims.
Yeah.
So those two forums are not really related to each other. They have independent jurisdiction. And so you can go straight to the Court of Federal Claims at the outset. And in fact, there are a couple of reasons that you might do that. Like, for instance, I've written about splits in interpretation between GAO and the Court of Federal Claims, where if you have the exact same facts, let's say you get the full record in both places and you have the exact same facts, GAO will deny your protest because of the way that they interpret the federal acquisition regulations, and the Court of Federal Claims will say, yes, you win. So if you don't know what those splits are, that can be problematic in making that decision, because if you go to GAO and you lose, and then you go to the Court of Federal Claims and win, that's great. You ultimately won, but you probably spent much more in legal costs and time because you duplicated the amount of protesting that you did.
Yeah, that's so interesting. I'll get that article from you and put it in the show notes, because that's fascinating. I'm going to go back to my original question. That sets that us at a really good level, but has anything changed in the past couple of years in terms of when you should be doing protests, when you shouldn't be protesting bids? Are there any differences, or is it being pretty much the same?
Right. Thanks for corralling me and bringing me back to your question.
I can't help it. I'm really
I went
curious.
off on a complete tangent. So the reason I was clarifying is because I think it's important to know the differences in the forum.
Yeah.
And, as I think you can tell from the way that I categorize them, I prefer to go to the Court of Federal Claims because you tend to get, I think, a more complete review and they're less deferential. But there are other reasons on top of that. And one of those is that GAO recently clarified in July 2025 its pleading standard. And so if you don't know what that means, you're like, David, you're off in lawyer land, put it into plain language. It just means that when you go to make your initial filing at GAO, the agency can move to dismiss based on a lack of facts or clear argument in your initial pleading. And so if your protest is going to rely on facts that are only in the administrative record, which you only get after a motion to dismiss or a request for dismissal is resolved, you may never get to the administrative record, which means you lose before you even began, really. And so the idea there is that you're supposed to cut down on protests that are speculative, right? That you have an inkling, or you have like maybe a vague idea, but you don't have enough facts to show that you deserve to move forward in the process at GAO. And when commentators, including me, were considering whether that would have an impact on protests at GAO and their success rate, there was sort of a split of opinion and a little bit of confusion as to whether they had just clarified the pleading standard as opposed to like increased the scrutiny. And I think it's pretty clear now, we're recording this at the beginning of March. It's pretty clear that GAO did not just clarify their pleading standard, they tightened it up. And that means that it's harder to get past an initial agency request for dismissal because GAO wants to see more than just mere speculation in the initial filing. And that has additional consequences that I think cements the three-tiered difference between GAO, the Court of Federal Claims, and the agency, making Court of Federal Claims continue to be the major leagues.
Yeah, gosh, this is why people need to hire you when they want to actually do this.
Oh,
But
and I forgot to say, the reason that it's clear, I'm sorry to interrupt, the reason that it's
oh,
so
sorry.
clear that GAO has tightened their standard is because there have only been 3 sustained protests so far in the first 2 months of 2026.
Wow.
And that's lagging pretty significantly behind. I'll just give you like a quick stats here. Typically, the effectiveness rates of going to GAO is about 50%. And the effectiveness rate means either you received some sort of corrective action from the agency or you won the protest on the merits. That's a sustained decision. So there may still be an effectiveness rate of around 50% at GAO so far. We don't know for sure because it's hard to tell. But I think that because there have only been 3 sustained protests, it's definitely below the typical 16, 18% sustain rate that we see there. And I think, by comparison, there are many more protests at GAO than at the Court of Federal Claims. And I think there have been at least 3 wins at the Court of Federal Claims since the year began.
Let's say I do want to protest, and I'm worried that that is going to damage my relationship with the agency. I know, like you said, like a lot of times they switch out who people are. These agencies are large, but have you ever seen that actually hurt the relationship when you're doing that, or has it really not been much of a factor, especially if when they are protesting it, it's for a legitimate reason and not ego-based?
If someone claimed that their relationship with a particular person or a particular part of an agency was ruined due to a protest, if they claimed that, I think it would be very hard to prove, right?
Yes, I mean, not legally. Have you seen them kind of feel that way or, like, worried
Yeah.
about like, maybe the right question is, like, do you feel like the worry about the damage to that relationship with the agency is usually not founded on anything? Like, is it more of, like, a worry without any actual consequences? Or is there something that they should be taking care of, like, when they are protesting to make sure that that relationship is sustained even though they are protesting, the decision?
Yeah, I think that relationships are really important. So I don't want to discount the way that people feel if they've had an experience where they think, they protested and the agency held it against them in the future. It could be the case. However, I'll say that, the way that the agency would hold it against you in the future is by discriminating against you illegally in a future potential award, right? So that would also be protestable because the agency is supposed to act fairly in all evaluations, regardless of whether or not you protested them in a prior evaluation. So I think you're probably right. I would say, I want to be careful. I don't want to say that it's completely unfounded to worry about your relationship with the agency, but it's my experience that even folks who protest quite a lot at the same agency, they tend to continue winning projects and they're still in business. And I don't see those ill effects. Now, I'll say that when I'm involved with a protest, I make sure that there's some merit to it, that there are colorable arguments and
Yeah.
that we're putting our best foot forward and that we're not just protesting because of ego. Like I said, I tell people probably 8 or 9 times out of 10, let's just save our money and focus on the next award.
Yeah, interesting. I hear that a lot, which is why I asked that question. And I do, because that comes up in quite a few things that we don't want to push back on, like FOIA requests, for example. We don't want to be annoying, but When is it needed? When is it not? Are we being as annoying as we think we are? So you've argued that debriefings need a new question, and that is, was GenAI used in the evaluation of bids? And if the answer is yes or evasive, like what should a contractor do if that is an issue?
Yeah. So this is a really hot topic right now. As you are probably aware, the government is trying, through the administration, they're trying to integrate generative AI or large language models, chatbots, however you want to think about it, into all facets of the government to try and get some of those efficiency gains that are promised by these products. And while I am currently unaware of a very clear case of use of a tool for evaluation of bids, I think there's no doubt that it's happening in some form or another on the government side. They're constrained in many ways by resources and personnel like contractors are. And I think even more so over the last year with all of the turnover in the government. So they're still procuring roughly the same number of dollars, but there are fewer people to do the evaluation. And I think it's only fair to uh, believe that the chatbot is being used in some way. Maybe they're summarizing your proposal and then they're starting from that summary when they're doing their evaluation. I mean, that could be a use case, right? In other cases, it's possible that the government is using like a specific tool that has Gen AI in it to do the full evaluation from soup to nuts. So the FAR definitely requires independent judgment from the government in evaluating a bid. And that means when you're talking about Gen AI tools, we know these things are basically black boxes where the math, the very complicated math that is used to create the outputs can't readily be shown. The work can't be shown. It's like when you do some math by hand and the teacher penalized you for not showing your work. So there's no notes that the Gen AI tool comes up with, or we know that if you asked it to come up with notes for why it arrived at the conclusion that it did, that they wouldn't necessarily relate to the output
Yeah.
perfectly. They wouldn't correspond perfectly. So I think it's pretty clear that if the government used a Gen AI tool or multiple tools to come up with a full evaluation of bids, that it would be a protestable issue. And I think it's extremely likely, again, there's no precedent yet. I think it's extremely likely that the court or GAO would say, yeah, this is not independent judgment. There's a lack of documentation. And as a result, we're going to tell you to reevaluate the bids. Okay, so that's one issue. There's official tools that the government agencies are entitled to use that are sanctioned by the government. And then there's, you use ChatGPT for things all the time, whether or not your office has a policy in place that says you can use ChatGPT. I think it's reasonable to expect that folks are using these things maybe only for part of the evaluation. Like I mentioned earlier, just summarize this bid for me so that I can know where to start. And that wouldn't necessarily be a sustained protest in that case. Like, let's say we proved they talked to the chat bot for a summary, but then they created their typical notes and they did the evaluation in accordance with the rest of the requirements of the FAR and the solicitation. I think that would probably be okay. So, but then there's that on one side, probably okay. And then there's the full evaluation on the other side, and that's not okay. And then there's this whole landscape in between where it isn't clear how a court would decide what level of Gen AI involvement is acceptable or unacceptable. And so it's a very interesting question. There are lots of people who are thinking about it. I mean, everybody's thinking about how to integrate LLMs everywhere. And, I do highly recommend Dean Jessica Tillotman from GW Law. She's written a lot on this subject, and I think she's probably the leading academic on the issue. And so I would recommend you check out her writing on this.
Okay, so David, are there any similarities between what proposal capture sales teams do on our side as what you do?
Yeah, there are a lot of similarities. So we both deal with deadlines on a constant basis, and those are stressful. And then we also deal with documents where precision is very important. So one way I like to think about the use of GenAI in capture that I think is very similar to my practice, where making legal filings all the time, is I think this matrix can be helpful where you sort of have an X and a Y axis. And on one axis, there's low risk and high risk. And on the other, there's low importance and high importance. And so when things are very important and very risky, for instance, a legal filing in a bid protest, then I think that use of large language models in creating that output should either undergo very strict verification processes or just not be used at all because of the risk of hallucinations. And you can fill in the matrix with your own use cases depending on exactly the sort of work that you do. But you could imagine in the low risk and low importance situation, rewriting a text to a friend to make sure that your meaning is conveyed well. The risk of hallucinations or errors there is very low. It's unlikely that there are facts that you're saying in this text to your friend about the fact that you don't feel like going out on Friday are going to be wrong. And even if there were facts in that were hallucinated and that were incorrect, you've got a good relationship with this friend and it won't matter. It's not important. And then there are the other parts of the quadrant where maybe it's very high importance. Like I think of this in like an initial case analysis situation where I've received a lot of documents from the other side and I want to go through them very quickly. It's a high importance task, but there's very low risk because I'm using the tool to sort of figure out what's here. I'm not then immediately taking the output and putting it into a legal filing, which falls into the high risk scenario. So, but I think there are a lot of similarities in the way that my profession and yours approaches the use of large language model tools. And I think it can just be sort of a useful heuristic to think before I use a large language model, am I falling into a risky side of the quadrant? And if so, what verification do I need to make sure that I'm not going to get burned? When I speak about large language models and when I write about large language models, I try to really narrow the aperture from sort of AI to legal to procurement litigation. So in that vein, I've written a report on hallucinations in legal filings from 2025. And, I covered it all throughout the year. I love it if you follow me on LinkedIn because I put out posts regularly discussing these issues. And I compiled all of my analysis into a report that I published in January. And I think it's really interesting to see how even well-trained lawyers are being, I don't want to say fooled, but they're having issues with accuracy for case citations and facts, and those are making their way into, again, the high risk, high importance part of the matrix. And GAO and the other procurement tribunals are not taking very kindly to hallucinations, especially with regard to case law. And you can understand why. That you may not care when you're submitting an argument whether the case will be used in the future. You only really care whether you win or you don't win. But the way that our legal system works is it's built on precedent, which means that if one decision has a problem with it and then the next person relies on that same decision, the problem carries through. And so from a systemic perspective, we care that all of the citations and all of the logic in legal filings is very, very accurate and factual. And as I'm sure everyone knows at this point, large language models can hallucinate all sorts of facts. If anybody is telling you that their technology has no hallucinations, they're selling you a bridge to nowhere. I'm sorry, I hate to say it, be the bearer of bad news. There are lots of things that we can do to try and reduce hallucinations, and I think that the technology gets better all the time. As the hallucinations get lower, our scrutiny of the outputs gets less. We apply less scrutiny because the outputs look really good. They look very plausible. And so as the tools get better, the hallucinations don't go away, but they might look even more plausible and there might be fewer of them, which means, and there are lots of studies on this, which means that we don't look as closely at the outputs. And as a result, we let slip some very, very important factual errors. And again, like if it's a factual error in a text to your friend about the fact that you don't want to go out on Friday, it doesn't matter. But if it's an error in a compliance matrix that you rely on in drafting your proposal, and you're disqualified from the award without even consideration of your proposal, that's really bad. There's a lot of severe consequences there. You've wasted a lot of money. And so you just need to understand where you're falling in the matrix. And I think that it's illustrative to look at how real cases at the GAO and the Court of Federal Claims that involve hallucinations, how they ended up the way that they did.
No, I find that fascinating. And I do want people to go and look at the report, but I find it fascinating because those hallucinations can be so problematic. I know this is B2B, but there is like a Forrester report that says they believe that legal claims in the US will go up by 20% based on AI hallucinations alone. And I have no doubt that that will translate into, federal government claims as well.
Yeah. So far, it's hard to disentangle the um, trend line. Let's say at GAO, the number of protests has fallen year over year for a good number of years, maybe 10 years. And it's relatively steady. It's plus or minus 2,000, but it's generally going down. But when I look at all of the cases that I discussed in 2025 and I think there's 5 cases so far in 2026 already, through February. And when I look at them, most of the filings are by pro se litigants. And what that means is that they didn't hire a lawyer and they used ChatGPT or whichever Gemini, Claude as their lawyer. And, so this is another principle that I think is like really useful for people to internalize. You have the matrix idea that I've put together, but also I think if you are asking a question from the large language model and you don't know what the answer should look like let's say it's in a domain that you're unfamiliar with, like let's say that you're not an attorney and you're trying to file a bid protest and a case comes out and you look at it and you're like, wow, that really supports my argument. Like that's a very good case.
Yeah, exactly.
But you don't know if it's a good case or not, and you don't
Yeah.
take the time to like look up the case and you file it, you're going to lose. Every single one of those cases that I've discussed so far that has a hallucination in it ended in a loss for the contractor.
Yeah.
So even if the hallucination, you just get warned rather than sanctioned, it undermines your credibility in a way that's very damaging. And I think there's at least a couple situations where I analyzed the case and I talked with some other attorneys about it. And I said, I think if their credibility hadn't been completely shot by the hallucinations, they might have had a chance at winning this.
So go hire David if you want to do a bid protest. Don't do it. Don't hire Anthropic to do it.
I also like to say, you don't need to hire me. Like you can follow some basic principles. Like if you want to do a pro se protest and you don't want to hire me, I get it. Listen, nobody likes paying lawyers. That's terrible. But what you want to do is you want to be really careful. If it's going to fall into that high risk, high importance quadrant, then you need to employ special verification procedures. And I'll tell you what, most of these cases so far have been at the Government Accountability Office. You don't need a Westlaw subscription to look up GAO cases. They're on GAO's website. If you get a case from ChatGPT and it says, this is a great case and it supports your argument, all you need to do is read the case. You can read, you can go to GAO.gov. And that's really all it takes to figure out whether or not you've got a hallucination. And I think the minimum amount of verification is just confirming that the case actually exists, because but then you get into what I was talking about earlier with hallucinations becoming more subtle. So, and they're not restricted to case citations. So sometimes it'll be summarizing part of your proposal and it'll say, we definitely included this discussion of X, Y, or Z that you said we didn't include in our proposal. And you can find it at pages 14 through 21 of our proposal. And then GAO takes a look and they look at your proposal and it goes to page 13. There's no pages 14 through 21. You never included that information. And that's a factual hallucination. You lose. You wasted all that time. You wasted GAO's time. You wasted the government's time. And that's the sort of thing where, no one has been debarred or suspended for filing a protest or a monetary claim that has hallucinations in the filings yet. But I've talked
Okay.
to experts in the area. If you're signing your name on something that has factual errors in it of that magnitude and you're certifying that all the facts are correct, I think it could potentially be a False Claims Act issue. And the consequences might go well beyond the particular dispute that you're in.
Yeah, no, I don't do that.
Thank you.
I mean, I'm a huge proponent of AI, but it's not an end all be all silver bullet. Okay. So let's say people like you put out so much work on LinkedIn. You're a wonderful person to follow. Where can people find you? How can we learn more about you?
Yeah, thanks. So my law firm, Burr Forman, has a government contracts blog where myself and other colleagues publish about timely issues. And so that's a good place to follow the work that we're focused on. I think there's a lot of overlap. Like I said, your audience is very focused on bids and proposals. And so I write a lot about bid protests, and there's a nexus there. Almost everything that I do when I speak, when I come on a podcast like this great one, I post about it on LinkedIn. So I think that's probably the easiest way to follow me. And then, you can go to my law firm's website and my phone number's there, my email's there, you can reach out.
Wonderful. Yeah. Thank you so much for being on the Stargazy Brief. And we'll have you on again sometime.
Thanks, Christina.
Hey, Stargazers, thanks for making it all the way to the end. If you found this interesting, if you know somebody who is thinking about maybe doing a bid protest or just wants to understand them, please give this a share. Go check out David and his blog posts, his LinkedIn posts. He is so informative, so interesting. You will learn so much on a continual basis, and you'll keep up to date in the news and what bid protests are happening right now. All right, I'll see you next week.